Claire Wathen from the Skoll Foundation is going to be joining us to do an introduction. But Claire, are you on yet? Okay, so she's not on yet. So in the meantime, let me introduce myself and the other speakers. We're really excited to have so many participants in this session. We have close to 100 people joining us, which we're really excited about. And the topic is legal empowerment, COVID-19, and expanding access to justice with technology. I'm Michelle Pistone, and I'm a professor of law at Villanova University, Charles Widger School of Law. And I'm really excited about opportunities to use technology and online learning in my teaching. And today I think we're gonna have a great discussion about this topic. We have a wonderful group of speakers from around the world who are joining us. And the agenda is really simple. Julie, how do I move through the slides? The arrow is not, it's not like moving it.
And, you know, Michelle, I don't really see many other people on our Zoom. Is there another link that people went to? Oh, here we go.
Okay, so now everyone should be here. Yay. Yeah. Okay, so let me start again. Hi, everyone. I'm Michelle Pistone, and I'm a professor at Villanova University School of Law. And I see that Claire Wathen is here from Skoll, and she just wanted to say some introductory remarks.
Thanks, Michelle. Hi, everyone. I'm Claire with the Skoll Foundation. Just wanted to say on behalf of our team, thank you so much for joining this conversation and the week. We would typically be in Oxford, but we're seeing an incredible gathering of people all across the globe, and really happy to have this conversation as part of that on day 3 of the virtual forum week. So excited to listen and learn. Back to you, Michelle.
Great, thank you, Claire. And we're really excited. So as I said, I'm Michelle Pistone, and I'm from Villanova. And we have a great group of people, international group of people here to discuss this emerging topic of legal empowerment, COVID-19, and expanding access to justice using technology. So we have an action-packed agenda with, as you can see, many people who are bringing their different perspectives. So Bridget Grammy is the Administrative Director at the Center for Public Interest Law at the University of San Diego. Crispin Passmore is from England, and he's going to talk to us about some innovations that are happening in England. Then I'm on the call. Mustafa Mahmood is the Senior Program and Advocacy Director at Namati. Stacy Butler is the Director of Innovation for Justice at the University of Arizona, and Zach DiMiola is the Manager of the Institute for the Advancement of the American Legal System. And I know we have a lot of other people on the call who are bringing their own expertise, so we've built into the agenda. How do I get to the next slide? So we've built into the agenda time for participation and discussion from the group. So we're going to spend the first few minutes just introducing, as we're doing now, and then Zach is going to set up the problem for us. And then we're going to open it up for discussion, and hopefully we can use chat and also just participate by voice to answer this question. If no regulations existed, where would we start to solve this problem? Then we'll talk about the regulations that do exist, and that would be Bridget and Stacy setting that up for us. And then I'm going to talk a little bit about COVID-19 and some new solutions that people have been working on. And then we'll have a group discussion about how to move this agenda forward. And then we have 2 international experts to talk about the experience in other contexts. and then we're going to end with insights from the audience. So that's the agenda for today. And so I want to hand it over to Zach.
Thank you, Michelle. My name is Zach DiMiola. I'm a former litigation lawyer, but today I'm a manager at ILES, which is the Institute for the Advancement of the American Legal System. ILES is a national independent research center at the University of Denver, and we're committed to improving the civil justice system in the United States. My task is to set up the problem, and the problem is an issue that deeply concerns us at ILES, and that is that the legal profession in the United States is not serving the needs of the vast majority of people with legal problems. So I've got quite a few figures up on these slides, and it's a little text heavy, but the numbers are astounding, and I think it's worth keeping them up. Low-income Americans are hit the hardest. 86% of civil legal problems reported by low-income Americans receive inadequate or no legal help at all. But the problem reaches far up the income scale. It's not only the poorest who lack access to legal services, but it's also the middle class and small businesses. Studies show that there are about 100 million people in the US at any given time living with civil justice problems, but on average, they seek lawyers or even consider doing so to help them with those problems, to help them with only about 16% of the problems that we know of. According to the ABA, in some jurisdictions, over 80% of the legal needs of lower to middle income individuals are just being unmet. And in 2015, the National Center for State Courts found that 76% of cases in state courts have at least one party that is self-represented. With over 90%, unrepresented parties were more likely to be found in debt collection and eviction cases. In some jurisdictions, over 90% of those cases involved an unrepresented defendant. And the center noted that economic hardships flowing from the Great Recession of 2008 were likely the reason for some of these numbers, and certainly that concentration in debt collection and eviction issues. So, what do these statistics really mean? They mean that people face major challenges in their financial security, their housing security, and their physical and mental health without any assistance. And we know that people forced to deal with issues like evictions or mortgage foreclosures, child support proceedings, debt collection cases, without any legal advice or representation, are severely disadvantaged. They do not get nearly as good of an outcome on average than people who have legal assistance. So people are encountering a legal system that they see as unfair and out of touch. And I should add, all of these numbers reflect a legal system that existed before the disruption of COVID-19. People want and need help. In 2016, ILES conducted its own study, Cases Without Counsel, and we focused on the experience of self-represented people in family court, which is, on average, where most Americans are likely to encounter the civil justice system. More than 85% of the people we talked to, they wanted advice, they wanted representation, but they couldn't get help they needed because either the cost was too high or they just did not know where to find the right resources. One participant told us, and I quote, "It felt very much like wandering through a room with no lights on. And you'd bump into something, you'd ask somebody about it, they'd shine a little flashlight and say, go that way. But nobody ever turned the lights on in the whole room to give us an idea of exactly what it should look like." The United States ranks 99th out of 126 countries for accessibility and affordability of legal services. Now, ironically, despite the immense need for legal services, lawyers are struggling to make ends meet. In the past 10 years, the number of lawyers has increased by almost 15%, but almost 32% of law school graduates in 2018 could not find long-term, full-time employment as a lawyer within 10 months of graduation. And this is something akin to a market failure, right? The supply for legal services, that is lawyers, continues to increase, but the demand is increasing at an even greater rate, and the two aren't meeting. And in fact, inefficiencies plague the legal profession, and that keeps fees for lawyers artificially high. A recent report on legal trends suggests that many lawyers spend much, if not most, of their time on administrative tasks and work related to marketing and earning new clients. The same report suggests that solo and small firm practitioners earn only about 1.6 hours of billable work per 8-hour day. This sort of dynamic puts upward pressure on the fees lawyers have to charge just to stay in business. And to make matters worse, lawyers are out of touch with and out of reach of consumers. I mean, we live in a world where solutions are often at our fingertips, right? Banking, real estate, delivery of food. Everything is immediately accessible online or through an app. Not so with lawyers. Due to regulations, and we'll hear more about that in a little bit, lawyers are locked into a 19th century business model that prevents them from joining just about every other industry in the US and taking advantage of modern technology and innovations in service delivery. So there's a movement for change in the legal profession in a number of states right now, and it's driven by the need for a more sustainable business model for lawyers. But it's also driven by a recognition that the American legal system faces a severe, and I would say even an existential threat, and that is public dissatisfaction and disengagement. Americans are getting used to the fact that they cannot turn to the justice system to solve their problems. So they're not. They're skipping it. Well, as lawyers, we are stewards of a justice system that is the foundation of our democracy. And we cannot sit idly by while that system continues to drift away from the very people it's meant to serve. We cannot expect people to confront legal problems without legal advice. And we cannot expect legal services to meet the needs of Americans unless we expand the reach of those services. So without change, access to justice, and maybe even the concept of justice, is becoming just a catchphrase that's losing relevance to most Americans. So we need help, we need change, and we need to think differently. And that's why we want to ask all of you the question, if no regulations existed, knowing the problems that I've set forward here, where would you start to start solving these issues? Thank you.
So thanks, Zach. And so we have about 5 minutes, 5 to 6 minutes to talk about this particular issue, to try to get involvement from the group, to think about if no regulations existed, where would we start to solve this problem? And you can either join with your voice, or you can add to the chat.
Michelle, is it worth me just saying something from England? Because most of our legal services here are delivered with regulations.
Yeah, that would be great. Thanks, Crispin.
So in England, it's worth just remembering that we don't have an unauthorized practice of law regime. Most legal services can be delivered by anyone. That's any individual, any business. What's restricted is just advocacy in higher courts, litigation, and 2 or 3 other things. So general advice about your rights, administration of public services, even advice resolving dispute, short of formal litigation, can be done by anyone. There is no regulation of that, sector specific. There's no state bar, law society regulation of all of those legal services delivered by others. There is simply competition law and consumer law. So we've got a natural experiment comparing England and Wales with the US, and what we've got is a thriving legal market beyond lawyers and law firms, non-profits, some with lawyers in them, but most no lawyers at all, just paralegals, just people that have decided to be committed to this, see it just as a job, like any other job, are delivering legal advice to people that are poor on housing, welfare, labour disputes, all of the things that people that are facing the current crisis are really seeing a ramp up in demand for. The evidence is they do it at least as well as lawyers. There's only limited research in most countries that have got this, but in the UK it shows just as likely to be as good as lawyers. But if you want excellence, you need to go to a non-profit, non-lawyer, much more likely to deliver excellence than lawyers. They deliver most of our legal aid services in these areas. But we also have a thriving commercial sector in this area. I think it's always good when talking to people in the States, particularly, to use the example of Rocket Lawyer. Roughly 1 in 10 US adults has an account with Rocket Lawyer, but it's not allowed to deliver legal services. Well, it is in England, it's welcome. It employs lawyers, it employs attorneys, it delivers legal advice. You can do that online, you can talk to a lawyer. And accordingly, we just have a more thriving and dynamic legal market. And that's even before we get to how we regulate, when we do regulate with ABS and all those sorts of things.
So that's really helpful, Crispin. And Zenobio Sish asked, how about a trusted marketplace where people seeking help can find it at a transparent price? And there's another comment about more investment in translating processes. So translating the laws into pro se friendly materials. And with respect to that second comment about translating the processes into materials that are accessible by the public, there are efforts to do that. And here in the United States, there are a lot of non-for-profit organizations that are attempting to make materials more accessible. One of the problems is that we have a regulatory structure, and we're going to talk about that next, that prohibits the unauthorized practice of law. And so there's a lot of stress for people who want to provide services to make sure that they're not violating the law. So let's turn to that discussion now. We have Bridget and Stacy, who are going to talk to us about the existing regulations.
Hey, thanks. And I think it's important, as Crispin just pointed out, that we're really coming at this from the U.S. standpoint, and it would be helpful for me at least to know, and maybe people can just put in the chat where you are all zooming in from, so we have a sense of what perspective that you're bringing. And I think what we have here in the U.S. is pretty unique compared to other countries like England and Wales that Crispin was talking about, and I'm guessing I know other countries around the world. But what we experience in the U.S. is something that we're trying to kind of change and crack the code on a little bit, and that's why we're loving to hear from all of you and different perspectives. So what we have in the U.S. that is, we believe, really causing part of this, or a huge part of this justice gap, are some obstacles. And one of them, just to explain, especially for those of you from outside of the U.S., a structural obstacle is that the legal profession, and really all professions in the United States, are regulated at the state level. And so you have 50 different models basically for the way lawyers are regulated, and they all do it a little bit differently. In every state, the Supreme Court is ultimately the decision maker and the one in charge, but there's varying levels of legislative involvement. In California, where I'm from, we have a pretty significant involvement from the legislature involved in the regulation of lawyers. In some states, and most states do not have that oversight by the legislature. And so it just complicates things when you have, you can't just have one law that, well, you can, but it would be, I think, pretty unlikely and very difficult to pass like a federal law that would apply to all lawyers, or that would apply to the regulation of the legal profession that in every single state. It's really up to each of the individual states. The other thing that's challenging about it is, are the decision makers when it comes to the regulation of the legal profession, and they are typically not policy makers. Courts are passive bodies that are used to having the evidence presented to it, and then they make, once people present the case to them, then they make a decision, but they're not active policy makers for the most part. And I think that is a structural problem as well. So I think the legal profession is pretty behind other professions when it comes to innovation. And Stacy's going to talk a little bit about the cultural obstacles that we face.
Thanks. Yeah, I think we have layers of cultural obstacles happening here in the U.S. And one of the most powerful is that lawyers are really trained to act from precedent and to be risk averse. And so lawyers in the U.S. want to go forward with change based on what's happened before. And that backward-facing position of the profession makes it really hard to innovate. And then innovation feels very risky to lawyers. They're very used to doing things the way that they've always done them. And so one thing we see as we're proposing regulatory reform in the United States is that attorneys feel very precious about their profession and the history and tradition of the profession, and really are not feeling very motivated, despite the market failure, are not feeling very motivated to watch that rich history and tradition be undermined by regulation. We also have a tradition and a cultural practice of attorneys acting through their professional judgment in decision making. We are not a data-driven profession, historically speaking, and so to propose making change based on an economic market failure data presented to lawyers is not really the language of our lawyers, and so it's hard to drive change through presenting the profession with metrics about why the existing system isn't working.
Great, and I think that's a good segue into the regulatory obstacles that we face too. We referenced the unauthorized practice of law, but do you want to talk about that a little bit more, Stacey?
Sure. I mean, every state has a slightly different version of the unauthorized practice of law statute, but largely what we see is that only lawyers can give advice, and that anyone who's not a lawyer may be able to give legal information, but they can't give legal advice. And in fact, in some states, it's a crime to give legal advice if you're not a licensed lawyer. And so when we're talking about trying to expand different service models, whether that's through technology or through training different tiers of legal professionals, there's really, again, a rich tradition of preciousness around the giving of legal advice, and a lot of pushback from the bar because they feel that they are the only ones with the sufficient ethical training and expertise to be able to really advise people as they navigate the profession.
Yeah, and that makes innovation very challenging, and also I think not worth investing in. I think that's part of the problem too, is we do see innovation, we do see new products coming on the line, but they're mostly being utilized by large law firms and big corporations. They're not necessarily serving consumers and like the one-to-many model of delivering services to actual people. And the ones that have emerged, like Crispin was talking about Rocket Lawyer, we also have LegalZoom and some others, they've had to really jump through many, many hoops in order to even get the products online that they do have. And because of statutes, it's just a very fine line of what is the practice of law, and some just kind of ridiculous things like, oh, well, you can tell them this is a form, but you can't necessarily say how to fill out the form, because if you tell them how to fill out the form, that's the practice of law. And these are the types of restrictions that are getting pretty ridiculous. You don't need to pay a lawyer $300 an hour to tell you how to fill out a form, but yet we don't have any kind of in-between license, like paraprofessional or tiers of legal advice, as Stacey was referencing right now. And so these are some of the things. The other things that are really challenging right now are these fee sharing and advertising restrictions. And just on a very high level, we have a prohibition. It's the concept of professional judgment or independent judgment that Stacey referenced earlier as the rationale. But basically, the lawyers are not allowed to partner in business at all with anyone except another lawyer to deliver legal services. And so that's really, we think too, a big obstacle to innovation. So I, as a lawyer, could not partner with my friend who's a tech developer to come up with an app or some kind of, system where we could help people figure out how to write their own will. That would be illegal for me to be fee sharing a non-lawyer. The rationale is that, well, we don't want businesses to take our their profit motivation. Businesses and corporations are motivated by profits, and lawyers need to be focused on their clients. And there's very little give right now from the legal community about the concept that lawyers could still preserve rights and still partner with non-lawyers. So that's some of the, those are some of the obstacles. Can you put the next slide up, Stacey? Michelle. Thanks. So we do have states that are trying to do some innovation here, and Stacey's going to talk about Utah and Arizona.
So yeah, Utah and Arizona, I think, are the furthest out of the gate on driving regulatory reform. Utah's big initiative is what they're calling the Regulatory Sandbox. So they're creating, I'm sorry, I have an unstable internet connection, so wave at me if you lose sound. Story of my life right now. So the Regulatory Sandbox is infrastructure where new ideas, new innovations, whether it's legal technology or different service models, can come into Utah and provide services in with supervision and with requirements that they collect data and metrics in the provision of those services so that the regulatory body can be monitoring for consumer risk. And if the players in the sandbox can demonstrate that their new models can go forward without putting consumers at risk, then they will continue to play in the sandbox. And if their new model isn't proving to be both effective and low risk, then they get out of the sandbox. Arizona is looking at, we have proposals right now open for public comment. One big one is the elimination of Ethical Rule 5.4, which would allow non-lawyers to co-own legal service providers with lawyers. Another big change that we're looking at in Arizona, and this is a change that Utah and Washington have already adopted, is the creation of licensed paraprofessionals. So someone who has legal training but not a JD and is able to provide legal services in a limited capacity. My program at the U of A has a pilot that's running right now that is training lay legal advocates from a domestic violence shelter, giving them a limited provisional license to actually allow them to advise DV survivors and in certain high need areas. We'll run that pilot for a year in Arizona and collect some data around the effectiveness of that model in hopes of being able to inform other nonprofit sector models of non-lawyers who are able to give legal advice.
That's great. And then in California, we had a task force, and it was called Access Through Innovation of Legal Services, and I was on that task force at our state bar. Unlike Utah and Arizona's programs, or initiatives, which were really driven by the Supreme Courts, ours was actually formed by the state bar itself as a regulatory body. And it included a majority of non-lawyers on our task force, most of which were more tech people that could give us the expertise about what kinds of technology could be available and how the laws and existing rules might be stifling innovation or certain products from coming online. And then we did have several lawyers as well. And the big two and our report actually just came out. If you want to find it, we can post it, but we put it on, it should be on the website of the bar's website. But basically our biggest two recommendations that have come out, one is also pursuing a paraprofessional track, a licensed paraprofessional track, as Utah, Washington, and now Arizona are proposing as well. And then we also proposed a sandbox like Utah's before we would just, like Arizona is proposing to eliminate 5.4. We received a lot of questions and challenge about how that would work in California. And so our solution was to propose a sandbox as well, so we could gather data before just changing the rule and figuring out from a risk-based, how is it working, like really closely monitor these types of new businesses that might come online, and then see how it's working before we would get rid of the rule. But we have been met with significant opposition from the lawyers particularly, and the bar is moving forward, at least with the licensed paraprofessionals. It's still up in the air whether it's going to vote to continue to pursue the sandbox or not. So that kind of remains to be seen. But it seems, for at least from a recipe for success standpoint, having really strong leaders in the Supreme Court, both in Arizona and Utah, has really been the key to drive the success of their programs and their regulatory reform, despite the opposition from the legal community. So there's our quick overview. And I think we'll turn it over to Michelle.
And so I've been writing down some of the places that people are participating.
Yes, thank you for doing that.
And it's Brazil, UK, Chicago, Tanzania, Pennsylvania, North Carolina, Chile, Argentina, Switzerland, Illinois, Rhode Island. So there's a lot of people from the US, but we have some international voices as well. And then there was a question about why totally eliminate the rule that prohibits partnering with non-lawyers instead of creating exceptions or modifications. So let's address that, and then I'll move on to my part.
So I have a response to that question. I mean, and I've typed this in the chat field, but another way to look at this is, why have a categorical prohibition on the sharing of fees or ownership for a legal service provider when there's absolutely no evidence that that sort of a restriction on economic behavior does anything to protect the public from harm, nor does it do anything really to protect the independent judgment of a lawyer. So for instance, in America, we've allowed lawyers to work within corporations, hired by corporations to handle their legal problems for years now. And we never thought that that would interfere with the independent judgment of a lawyer, right? The other question to ask is, why aren't we prohibiting other sorts of economic behavior that potentially puts pressure on a lawyer's independent judgment? Exhibit A there is the ballooning debt that any lawyer has to take out to graduate from law school. Or even taking loans to finance a partnership, right? There are financial pressures on lawyers all the time from third parties that we seem to be perfectly fine with. But the biggest issue I have is that I'm not aware of any data, any objective evidence that supports the existence of Rule 5.4. And this may go a little, I mean, I think Crispin could probably take this argument a little further, right? In England and Wales, they don't have that rule. And I mean, that we have data that eliminating the rule doesn't lead to the sorts of harm that the rule, at least in the US, ostensibly exists to protect us from, right? So this goes back to, in my view, if we're going to have regulations on behavior, we have to base those regulations on objective data, not on unproven assumptions.
You see, if I can jump in, I disagree with your proposition that there's no evidence that it affects lawyers' independent judgment. I'm not aware, I haven't studied this, I'm not aware of empirical studies. My anecdotal observations in the kinds of courts I practice in are that it does. Most lawyers are motivated by the profit motive. It's human nature. I already see so many compromises of ethical rules, even with the ethical rules we have in place. I'm not totally opposed to these innovations, to relaxing the rules, but I think it's just incorrect. I think it doesn't affect lawyers. We're humans. I happen to be maybe a little bit of an outlier because I'm a public interest lawyer, so I really didn't go into it for the money. I'm a little old-fashioned in that I truly believe in professional standards. I often, not that they're perfect, but I often compare some of the decisions we make to doctors, and how would you like your doctor to make a decision about your health when it comes to the doctor's profit motive or your needs? Something I've become very concerned about are litigation funding schemes, including those, there's a proposal in New York to allow them, or I think they already exist, that lend plaintiffs money based on potential outcomes in personal injury and wrongful death cases. And a lot of these systems are really hurting the people who need it most, not the elite who have money and education and can, negotiate for their rights, but lower and modest income people. And I will say I'm definitely open to some innovations. I think we should have something like paralegal practitioners for us. I don't think lawyers are needed for everything. I'm often an outlier in that view in the community. I mean, something that came up in New York because of all of our high volume of consumer debt cases, which I know is going on across the country. It's kind of like housing court, was to create this class of non-lawyer practitioners to help people. And almost every legal services attorney was strongly against it because they were concerned about the quality of representation, and that, you often need, a lawyer at some point at least to supervise. So I do think a regulated, I don't see how you do this without, I think you need a regulated and supervised system to do this.
Yeah, and Gina, that's such a good segue into what I'm going to be talking about. So thank you for setting me up so nicely.
Great. Well, similar on minds. Yeah.
So the other thing that kind of is looming, and Zach talked about this a little, is that we had a significant access to justice problem before COVID-19. And now we can just imagine the sorts of legal needs that people are going to have after this stay-at-home order, and as people start getting back to work. We'll see bankruptcies, we'll see probably increase in divorces, we'll see a lot of landlord-tenant issues, evictions, and all of that on top of the existing legal needs. So as Gina mentioned, and others have mentioned as well in the notes and the comments, there are some lessons I think that we can learn from the medical profession. The medical profession has done a great job of creating additional layers in the healthcare system, in the ecosystem there. So we have nurse practitioners, physicians assistants, technicians, et cetera. And we see, especially during this pandemic, how they are so vital to the response of the medical community. And so one idea, and one thing that a lot of people are working on, is to think about how we can create paraprofessionals in the legal system equivalent to or akin to the nurse practitioners, physicians assistants that we see in the medical field. So over the last few years, there's been some movement in that direction. So the first state to start working on this and thinking about this was Washington State, and they started a limited license legal technician program, which allowed for the limited provision of legal services in family law cases. And then interestingly, administrative agencies, so federal administrative agencies, have had on their books, in some cases for decades, provisions that allow for non-lawyers, for people who are advocates, to help people in administrative proceedings. So there are regulations that allow for in tax, for example, for non-lawyers to represent people in tax cases. Veterans Affairs also has similar regulations, and so does immigration. And immigration is my specialty. And there are regulations that have been on the books for decades in immigration that allow for non-lawyer accredited representatives, so people who are accredited through the Department of Justice. When they work for a not-for-profit organization that's recognized by the Department of Justice, these individuals can provide legal services in administrative proceedings, just like a lawyer would. So in those cases, they can both represent immigrants in cases before the Department of Homeland Security. So those are usually applications before U.S. Citizenship and Immigration Services. And if you're a fully accredited representative authorized by the Department of Justice, you can even represent an immigrant in immigration court, just like a lawyer would. So I'm starting a program, I'm piloting it now at Villanova, which we call Vista. And it's really taking all my experience over the last 20 years training lawyers to become advocates for immigrants and using that to create an online interdisciplinary program to train up these immigrant advocates. So that's an example of how we're trying to start to build capacity in these adjacent areas for paraprofessionals and hopefully make these programs proof of concept for expanding it into other areas. Similarly, Stacy, who's also on the call from University of Arizona, has started a program, she mentioned it earlier as well, the Innovation for Justice program at the University of Arizona. Again, she's working with the state bar to create an opportunity for advocates to help people in domestic violence cases, even if they don't have a JD. So those are opportunities, and we see that there's a beginning to work on thinking about how to create these additional layers in the legal services ecosystem. And as I did research on this, I realized and learned that Duke University, the reason that we have nurse practitioners is because Duke University started training them 50 years ago. And the same thing with physicians. I think it was physician's assistants were started at Duke, and nurse practitioners were started at Colorado, at University of Colorado. So it was universities like Arizona and Villanova now that are leading this effort to train people, and then hopefully as they're trained, they'll be able to be providing those limited legal services. And then the other movement that we're seeing is the provision of legal services through technology. So good examples are LegalZoom, but we're also seeing increased use of technology for adjudication of disputes. So the Civil Justice Tribunal, which is in Vancouver in Canada, is an online tribunal that deals with small claims court proceedings. And they're seeing that this is much more efficient and effective in the adjudication of cases. Similarly, Modria is, actually Modria was started as the dispute resolution arm of eBay, and it was also used for PayPal. And now, millions of cases have been resolved through Modria, which is a technology, and many times without involving any lawyers or judges. And so there are opportunities to use technology to even resolve cases. And Richard Susskind just came out with a book on online courts. And so I'm sure we'll see more about these ideas of online tribunals and how to use technology, both to replace the adjudication by an administrative body, or also to allow for litigants to submit their documents outside of a traditional court setting, so that it's not as burdensome on them to get their materials to the court and submit their evidence, et cetera. And then, and this is something that Zach mentioned when we were in the call preparing for this, we're seeing an increase in, as a result of COVID-19, a lot of people creating wills. And it turns out that people are bypassing the legal system and using online providers and not using lawyers. So this kind of, I think, harkens back to what he said earlier, which is if the legal profession doesn't react effectively to using technology and making legal services more efficient, it's possible that we'll have a system that doesn't rely on lawyers as part of the provision of legal services, which I think would be a big change, at least. So now the next thing that we wanted to do was talk about, to try to get advice from everybody about how to move an industry like this forward. And we have about 12 minutes, 15 minutes left. And I also want to make sure that we hear from Mustafa from Namadi. So if you're on the call and would like to add your perspectives from Namadi, that would be great as well.
Yes, I've been following up on the conversation, and do I begin my presentation now, or do
yes, that would be great, Mustafa. Do you?
Sure.
Did you give me slides?
Yeah.
Okay.
So maybe we begin with the first slide. Just a background, I work with Namati, a legal empowerment network that works closely with community-based paralegals, that we believe in the mantra of knowing the law, using the law, and then shaping the law where the law does not protect the communities. I work with the citizenship program that basically we work with communities that are considered citizens by law, but in practice, they are not given equal rights. I'll give you a good example of the Nubian community. where they've been in the country since before the independence, and the Kenyan Constitution says if you are in the country by 1963, that's the time that we got our independence, you qualify to be a citizen. But unfortunately, by practice, they have to go through differential treatment. They have to apply on certain days. That's Tuesday and Thursday alone. And all this is a hindrance because basically other Kenyans can apply any day of the week at any time. So maybe we begin with the next slide, Michelle.
Yeah.
So in Kenya, we have over 5 million communities, 5 million individuals who are citizens, but when they apply for documentation, they have to go through different practice, like I told you about the Nubian community. So we work with communities in Kibra, that is in the capital city of Nairobi. And then we have in Garissa and Wajir in Northeastern, where we work with Kenyan Somalis. And then in Mombasa, Kilifi, and Kwale in the coastal areas, where we are working with the Swahili, Arab, and other stateless communities, that basically, as I said, they are considered as nationals, but in practice, they have to go through different practice in application of documentation. And our approach to this is we use paralegals to address the issues of discrimination. And these community-based paralegals help community members to navigate administrative systems where you don't need a lawyer, or you'll be using a lawyer's skill to tell him to fill a form, to tell them to go to a different office and all that. So basically these individuals are trained on the laws and the practice and the procedures of application, and then they help communities navigate these systems. A very good thing to note for us is we are so tech savvy. We use a common platform to collect our data. And if you see on the screen, we also use community paralegals to do on-ground work through community forums and even home visits. And we also use radio for community empowerment. So if you go to the next slide, I'll talk about how we use data. So as I said, we are so data-driven, and we use a common platform to collect all our data. It's called Salesforce. So all of it is used online. We use tablets and computers to collect the information real time. And through this, we collect a lot of information from the first time of application to the last day of issuance, first time to visit the government office to the last day they get a document. And this, we use the information collected in two ways: to shape our program, the same way we say, know the law, use the law, and then shape the law. So we want to see what's working, how do we shape our programs on all that. At the same time, the loopholes in the law. So maybe the next slide. So in 2015, we sat down and looked at our statistics, and we realized that it is easier for someone to get a birth certificate, an average of between 20 days to 51 days, you could get a birth certificate, whereas an ID, it could range between 74 days to even a year. So we realized it's not worth to invest most of the time of the paralegal to work on birth certificate issues, which even an individual, if they're guided well, they can do it themselves. So we had several mobile birth exercises to help eliminate the backlog of birth registrations. And all this was influenced by the fact that we collected data to see how long it takes to get a document, what are the requirements, and from that best practice, we were able to shape our program and focus the energy of the paralegals to other harder challenges. So maybe the next slide. The same data we've also used to shape the law and also do our advocacy. We've been doing advocacy regionally because the whole program is based on a regional decision by the African Committee of Experts on the Rights and Welfare of the Child that had a ruling on the Nubian minors case in 2010. And it highlighted on the issues of discrimination. So we had in 2014, based on all the data of the paralegals, we wrote a paper to the Committee of Experts on the Rights and Welfare of the Child, showing them that, in fact, instead of the government taking proactive measures to address the issues of discrimination, it has even taken worse measures to even further discriminate against the community. So that slide shows some of the screenshots from the briefing. Then the next slide, this slide basically shows an extract of that information. We are showing them that there are more cases of people who applied for ID cards and were asked for more documents. Like we saw issues of many people, because the 2010 Constitution basically says you can use either of your parents' identity cards as a supporting document. But for this case, we were able to prove that for Nubians, they were asked for more documents to prove that they're Kenyans. So from these extracts from real-time data, we're able to prove our case on issues of discrimination. So the next one, please. So now, luckily, as I said, our database is cloud-based. So it allows paralegals to work from home and through their tablets or even their phones and their computers. We've provided them airtime for internet bundles so that they could be able to follow up on some of the cases that they've had pending. And we've generated reports that could allow them to know how many cases have not been attended to within the past 2 weeks, 3 weeks, and even a month, so that they could follow up with the clients and see where they had reached to the application. So during this COVID-19 pandemic, they are working from home, and their role is to basically follow up with their clients and asking them, well, how were you able to submit your documents? What were the requirements that you were asked? Did you receive your documents? Because some of the paralegals have over 2,000 cases. So it's giving us enough time to now review all the cases that we've had and see what we can do with this time to address the backlog that they've had. And the other thing that, because they cannot do outreach, door-to-door outreach at the moment, we've just resorted to continuing with the radio show, where they continue giving information on issues of rights and procedures and requirements for documentation. So right now, everything is more remotely, and with the use of radio, we are able to still continue with the aspect of empowerment, because they can give information. They're not giving legal advice, but they're just telling you the process. If you need an ID, these are the requirements, because it's in the public domain. But most of the times, you see, the way we look at it is that the paralegal is more like that shadow that gives you comfort that, you know, I'm not walking alone. There's someone walking with me, and it gives you the confidence that I will go through this with the support of a person who has also gone through this and understands the procedure well. So basically, that's how we look at our approach.
In immigration, we're calling that accompaniment, that ability to accompany someone through the process, even if you can't provide legal advice or help, but just being there is useful. But it sounds like you've gone beyond that. And it seemed, I'm just curious, Mustafa, are the paralegals collecting the data that you showed us in that graph table?
Yeah, if you go back to the table that I showed,
I don't know how to go back.
So basically, what the paralegals do is that we collect issues of the documents requested, the time taken from the first time. They collect all this information, and they also monitor from the questions you've been asked during the vetting, where you've been called in front of a security panel. Are there any other additional documents you've been requested? Were you denied? Who denied you? The reasons for denial, and if it was successful, did it delay, and how long did it delay? So basically, the paralegals collect this information from the first day until the day that it's issued. And then later on, we do calculation in the back end, basically looking at the date of application and date of issue to calculate the average time taken to get the document. So they do the manual collection of data, and then the other things like total time taken are usually just generated in the backend.
Right. So it seems interesting, and that's another thing we can maybe add to our arsenal in terms of these paraprofessionals, to not, like, we think of paralegals in the United States as people who are working with a lawyer and kind of in the office supporting a lawyer and maybe more administrative tasks. But it seems like in your model, the paralegals are actually out in the community collecting data, interacting with clients, and providing the information that clients need. I mean, a lot of, and one of the comments earlier was that there are people who are creating information for clients, but it's not getting to the right people at the right time. So maybe it is this method of including another layer, which would help to be the translator of the legal information and be that person who accompanies, even if it's not providing any types of legal services. It's an interesting idea, I think, to add to our arsenal. So we don't have much time, but I'd love to know if there's any other like thoughts from other people in the audience or some of the panelists.
Michelle, I'd just add a couple of things, if I very quickly can. You know, all of the discussion about paralegals, non-lawyer ownership, non-lawyer involvement, tech companies, it's all dealing with, all of the concerns about it are dealing with theoretical, unevidenced and unconvincing risks. And there's a real and present challenge, which is access to justice for millions of people. It's not theoretical, it's not unevidenced, it's there in our communities every day. And which one of them are we going to focus on? You know, and what really is the problem with non-lawyer involvement? You know, are attorneys and state bars and the ABA, are they really telling me that attorneys' ethics are so weak that if they form partnerships or work closely with the rest of humanity, they're going to do bad things? Yeah, it's just absurd. And then finally, yeah, what's the real choice here? It's not whether this happens or not. You don't get that choice. It's already happened. You know, Axiom's 20 years old. Elevate, in effect, runs a law firm in Chicago. Fisher Broyles, a worldwide legal business, will float in the next 3 years, even though it's regulated in several US states. Yeah, there are so many ways around silly restrictive regulations that the choice is actually simply not does it happen, it's do you regulate it? Yeah, this is already happening. And like every guild in history, lawyers and state bars become irrelevant if they don't keep up with modernity. You know, so the choice is not, do I want this to happen? Too late. Customers are already choosing it. 25 million US adults with Rocket Lawyer and many, many others. Yeah, the choice is, do you want to regulate this stuff and make sure that it meets the right standards?
Yeah, and so that gives something. Well,
I was gonna. I wanted to. So I think everybody probably knows I agree with Crispin on all of that. But I did want to make a comment on Mustafa's presentation because I think it's fascinating that paralegals are out there and broadcasting to the public at large what their rights are. I think we have a culture that's developed in the United States where people are so far separated from the legal system and from sources of information that they, and this is some of the data I didn't share, they don't even recognize when they have a legal problem. When they have a problem, they just think it's a problem that they have. They don't recognize they have a right that they can redeem. And I think if we were to do anything near to the program that Mustafa presented on, it would go a long way in changing the culture in the US so that people knew what their rights were, understood that they could do something about that, and might bring them closer to the legal system.
yeah,
And I wanted to add, if in 30 seconds, I did want to acknowledge Gina's concerns because that's something in our work at the California State Bar, we really tried to reach out to a lot of different groups, and we heard very strong opposition from the legal services community, public interest lawyers, but people that are working on the ground like Gina and really do experience either lawyers or non-lawyers behaving badly and are very concerned about their own clients that are vulnerable. And I think what's important to remember, though, is that these things are happening with the laws that are existing right now, and they're not like the existing ethics rules are not necessarily preventing people from acting unethically. We can't change that fact. And the other thing is what's happening is by protecting consumers, by putting these in under the auspice of these rules, by saying we're protecting people, we're protecting them right from having an attorney at all. So right now, like, they're alternative for a lot of people, especially those who can't even qualify for legal services here. They just choose to have no lawyer. And so we're trying to think about different ways to change the system. But I just wanted to acknowledge that your concerns are legitimate. It's just we're trying to figure out different ways to deliver services and still maintain that protection for the public.
I just want to say thanks for acknowledging that. And I think, a lot of the people who are huge proponents of this with very little regulation really need to listen to the people on the ground and understand what we're seeing. And true, I mean, we're thinking of taking some of our work in the area of, attorney grievances, more of them, because there's a huge enforcement issue. And I'd love to, if anyone would like to invite me to, talk about these issues some more, I'd be happy to talk to you about exactly what we see all the time.
Yeah, and Gina, I also want to tell you and everybody else that there are a lot of states that are beginning to look at these issues, and they're asking for public comment. And so there are opportunities to share your perspectives. And I really think, honestly, the conversations that I've had with some of the regulators, they really want to hear from people on the ground to understand what's happening. And so I think, you and others who are clinicians have a really important voice in this conversation, because you're working with these communities that are disenfranchised and don't have access typically to legal services. So how do we create a system that's just for them, but also, and maybe recognizes that for many people, the alternative is nothing at all.
Right.
So if there's any other last comments, if not, I managed to record this, so I will make it available to everyone. And, this is an ongoing conversation in 50 states around the nation. And so there's going to be lots of additional opportunities to get involved. Chase Herzl, who's on the call, is working with the ABA, which also has an innovation task force. And so that's another place where you can share your voice through the ABA, which is, we'll get it out to the 50 states. And so,
and Michelle, I'd just like to put a plug in. ILS has a project called Unlocking Legal Regulation, and we've been working closely with Utah in particular, but also providing support to Arizona and other state task forces. We have a knowledge center online for anyone who wants more information on what these issues are and what different states are doing.
Michelle, this is Chase. Can folks hear me? Yeah, thanks for the plug there, and Zach. Love the work ILS does. Your Unlocking Regulations knowledge center is fabulous. I dropped the link in the chat here, but yeah, if folks have questions about some of these efforts that are underway and how I can help bring your voice to stakeholders at the ABA, please feel free to reach out to me. I'll drop my email in the chat. Yeah,
so Gina, I think, would be a great person for you to, for you two to get together as well.
Great. Would love to do that.
Mm-hmm.
Okay, well, thank you so much, everybody. This has been great. And yeah, we'll continue the conversation. Take care.